All right, this morning I'm going to answer the question, do I need to get a prototype done if I'm going to proceed with a patent? Hi, I'm JD Houvener, owner and founder here at Bold Patents Law Firm. I've helped inventors now for over 10 years, helped them acquire almost 500 patents as of today. I'm also the author of Bold Ideas, the Inventor's Guide to Patents. And I've also put together this really cool Inventors Kit. Click on the link below, get access to information that I put together for you to get started today. All right, so this question is good. It's about prototyping, actually building your invention. And the technical answer is no, you don't have to prototype to get a patent. It used to be the rule 10 or 20 years ago plus. You had to submit or show evidence that your invention works the way you say it does. Now, examiners are even better. They're able to do enough research and evaluate the specification to say, nope, I can understand this well enough. And that's the new standard, that they could go build it. So someone like you in your field of technology, even if no one else is doing it, right? It's cutting edge, first of its kind. So long as you can write it down in words and explain it through drawings, that someone like you could actually go make it, go build it, whether that's digital or, of course, in the real world. So that's the little detail you need to submit to make sure your application is what's called enabled. But in the real world, when it comes to actually making money and putting a business plan together around your invention, I always encourage prototyping, building out your invention before you move to the next level, whether that be a non-provisional or maybe even responding to an office action, to make sure you know exactly what your product's going to look like as you go to market. What we don't want to have happen is if you don't prototype, you're not really going to know exactly what it looks like, what the final product is. And what the problem might happen is the patent you'll succeed in getting will not match what you're selling. Ideally, you file, let's say, a provisional, begin making some actual first prototypes, working with a manufacturer, designer, and over the course of that first year, it gets refined. It gets really detailed. And now you have a nice finished product ready for sale. And that's what you want to file your non-provisional patent application on. Now, it can look a little different. Let's say you've done some of that local manufacturing, but now it's going overseas to higher levels of production. And they're going to tweak the manufacturing. They're probably going to want to change the material types and even the packaging. And after you sell your first batch, maybe you'll get some interesting feedback from your customer about needing to revise or change or adapt your design. Those might turn into new inventions, and you could work toward filing subsequent patent applications to protect those new improvements for version 2, 3, and so on. Hopefully, to answer your question about prototyping and how it's really not necessarily required. It's usually suggested, something I always recommend you do to get a better patent and to make sure your patent aligns with what you're eventually going to be selling. All right, everybody, have a good rest of your day. Go big, go bold.